My name is Cristie Ford. I'm a professor and chair of the Center for Business Law at the Peter A. Allard School of Law at the University of British Columbia. We have a bit of a handle these days. And it's my distinct pleasure to be part of this event, which has been marvelous, both in Vancouver 2 days ago and here. I'm the chair, and will keep my remarks brief, but I'm here to introduce our three panelists. We're going to start with Joanne Metear, who is Head of Corporate Finance at the Ontario Securities Commission, to speak about the regulatory perspective on disclosure in particular, our panels on disclosure. After which we'll move to Judy Cotte, Head of Corporate Governance and Responsible Investment at RBC Global Asset Management. Following which we will have Sarah Barker, whom you've already met, Special Counsel at Metear, Ellison. In view of time, I'm going to crack the whip a little bit, and everyone will be kept to as close to 15 minutes as possible. We should still have time for questions. And with that, I'll turn it over to Joanne.
So I do have slides. Were they going to be posted? Yep. Oh, sorry. Are they doing it remotely? Okay. It's the OSC presentation. Thank you. Great. Well, thank you very much for having me here today. I'm a manager in the corporate finance branch at the OSC, and I am here to provide the regulators' perspective. That being said, I should clarify that any comments I make today represent my own views and not necessarily the views of the Commission or other Commission staff or of the Canadian Securities Administrators. Okay, so to provide you with a roadmap for the next few minutes, I'm going to start off by providing some context for my comments. I'll talk about how the disclosure requirements under securities legislation apply to material climate change risks and opportunities, and how our current framework aligns conceptually with some aspects of the FSB's task force final report. In doing so, I'll cover the concept of materiality, and I'll finish off by talking about our current CSA initiative on climate change-related disclosures, including some of the issues that we're thinking about. So, to start off with a bit of background, we have seen an evolution in ESG issues, and in particular the E aspect, including climate change. For example, there's a changing regulatory landscape. We have seen governments starting to pay more attention to climate change, with the Paris Agreement being top of mind. But we've also seen several voluntary disclosure frameworks that have been proposed, including the publication of the FSB's Task Force Final Report. In addition, there has been increasing investor interest in environmental matters. And it's natural that as investors become increasingly aware of the potential risks and opportunities that climate change can have on their investments, that they would seek out additional information on it. Some of the larger institutional investors in Canada are seeking out climate change disclosures from some of their investees. Generally, this is done through an engagement process, but also in some cases through proxy voting and survey requests. So some of the concerns that we've heard expressed by investors is that climate change disclosures is not always transparent. And what that can mean is that it's either boilerplate or vague or incomplete, or in some cases non-existent. Some other concerns expressed relate to the lack of consistency and comparability of disclosures. So in light of this context, we wanted to assess whether there is a need for a further regulatory response. As a securities regulator, we do have a dual mandate: investor protection and fostering fair and efficient capital markets and confidence in those capital markets. So as a result, our focus is on transparency. Do investors have the information they need regarding material risks and opportunities of climate change, the impact on the business, and how the issuer is managing the risks and responsibilities? So on the next slide, I've set out what could be encompassed by climate change, as it is important to frame the issue. And one of the points I'd like to emphasize is that climate change-related disclosure is not how an issuer impacts climate change, i.e. whether or not it's emitting gases, but rather it is how climate change may impact the issuer and its business. It's not a specific industry issue, but rather all issuers need to consider if climate change would have a material impact on their business. So while we're currently engaging in a climate change disclosure review project, I think it is helpful to remember that there are existing disclosure requirements under securities legislation relating to climate matters. This slide is primarily a reference guide. Outlined here under National Instrument 51-102, Continuous Disclosure Obligations, are some of the main documents in which we would expect to see climate change-related disclosure. The next category of documents are those that address governance and oversight requirements. So looking at some of the specific disclosure requirements, for example, we have rules in place that require issuers to disclose the material risks and other matters affecting their business, including environmental and climate change risks. These could include physical, regulatory, and reputational risks, as well as risks associated with an issuer's business model. These are very similar to the categories of risk identified in the task force report, which included transition risks, such as policy and legal risks, as well as technology, market, and reputation risks. In addition, the report noted acute and chronic physical risks. There may also be opportunities associated with climate change, including new technologies, collaboration, or new markets. That is also an area in which the task force report highlighted, noting resource efficiency, energy source, products and services, markets, and resilience as examples. Issuers should also consider the impacts of climate change on their financial results, including the impacts on revenues, cash flows, and expenses, as well as asset values and liabilities. In addition, there are certain disclosure requirements relating to risk management and oversight, including disclosure regarding environmental policies fundamental to an issuer's operations, and board or board committee responsibility for risk oversight. This is another area of alignment with the task force report in a general sense, as the report contemplates descriptions of the board's oversight of climate-related risks and opportunities and management's role in assessing and managing them. So I wanted to spend a bit of time on materiality, as it is a key concept in our disclosure regime. It is the lens through which all disclosure requirements should be assessed, as only material information is required to be disclosed under securities legislation. That concept also comes through in the task force report, as it recommends certain disclosures where they are material. The test for materiality under securities legislation is a reasonable investor test. Basically, the test is whether a reasonable investor's decision to buy, sell, or hold the securities would likely be influenced or changed if the information in question was omitted or misstated. If the answer is yes, then the information is likely material. And I do want to emphasize that it is the test under securities legislation, which may differ than the test under some voluntary disclosure frameworks such as the GRI, which considers materiality from a broader stakeholder perspective. And I do want to emphasize this point, as a key objective of climate-related disclosure under securities legislation is to provide investors with all relevant material information that could affect their investment decision. It is the issuer's responsibility to make materiality assessments, and what is material to an issuer will depend on its particular circumstances. In some cases, however, we are seeing materiality being interpreted somewhat narrowly. For example, in some cases, we see this as being interpreted as disclosure of material risks which are fully crystallized at the time of disclosure. So how materiality assessments are being made by issuers in the climate change context is something that we're interested in better understanding through our current initiative. And as Andrew alluded to in the earlier panel, this is an area in which we have been asking issuers about their materiality assessments. So to assist issuers with making materiality assessments in the context of environmental risks, we have identified 5 guiding principles, and I do think they bear repeating. First, there is no bright line test or uniform quantitative threshold at which a particular type of information becomes material. Materiality will vary between industries as well as among issuers. And so in our view, issuers should consider both quantitative and qualitative factors in determining materiality, particularly in the context of climate change. It's also important to consider the context. Some facts are material on their own, but others are only immaterial in light of other facts. So an issuer should not lose sight of the forest for the trees by assessing materiality on individual information piecemeal. Determining whether information is material is a very dynamic process that depends on the prevailing circumstances at the time of reporting. So in assessing materiality, an issuer should consider whether the impact of an environmental matter might reasonably be expected to grow over time, in which case early disclosure of the matter may be important to reasonable investors. And this is particularly important where an issuer is in an industry with longer operation or investment cycles, or where new technologies will be required. It's also important to consider the probability and magnitude of the environmental trend. And finally, when in doubt, we encourage issuers to err on the side of materiality and disclose the information. One tool that could be of assistance to issuers is the SASB Climate Technical bulletin, which does include materiality mapping. And it's interesting to note that out of the 79 sectors in the report, 72 have identified material climate-related risks. So in October 2010, the CSA had published guidance on these disclosure requirements and how they apply to environmental matters, including climate change. And that the guidance was set out in CSA Staff Notice 51-333. Some people have asked us, does this notice still apply today, given that it was published 7 years ago? And how does it relate to climate change? And the answer is yes to both questions. The notice is still relevant, given that we have not substantially changed the disclosure requirements, and it does apply to climate change where climate-related matters are material. The guidance addresses 4 key concepts: materiality, environmental risks and related matters, forward-looking information, and risk oversight and management. And these are the themes that are still being discussed today. So I wanted to finish up by talking about our current initiative, which is involving a review of climate change-related disclosures across Canada. There are 3 key objectives for this project. First, to assess whether current Canadian securities legislation and guidance are sufficient for issuers in providing these disclosures. Second, to better understand what climate change-related information investors need in order to make informed decisions. And lastly, to see whether or not issuers are providing appropriate disclosure in this regard. Our project has 3 primary work streams. First, we are conducting research. We have reviewed climate change-related disclosure requirements in other jurisdictions, such as Australia, the UK, and the US. We have also looked at voluntary disclosure frameworks, and while there are quite a few of them out there, for our project, we focus primarily on 4 of them, being the FSB's Task Force Report, the International Integrated Reporting Framework, the Global Standards for Sustainability Reporting, and the Climate Risk Technical Bulletin published by SASB. The second work stream is to review climate-related disclosures currently being provided in Canada. We reviewed the disclosures of a select number of large TSX issuers across a variety of industries. Our focus here was to specifically look at the climate-related disclosures that were being provided in their securities regulatory filings, as well as any voluntary disclosures that these issuers have publicly provided. The final work stream is stakeholder consultation, which had 2 components. First, in addition to our targeted disclosure review, we wanted a much broader sweep of all TSX-listed issuers. So we sent out a voluntary online survey to them on an anonymous basis. Our goal here was to better understand and really get a candid response from them in terms of what climate-related risks they are currently disclosing, where they are disclosing that information, i.e. in regulatory filings or in voluntary disclosure, what are some of the costs and challenges associated with providing that information, and what their governance process was in terms of identifying and managing climate change-related risks. The other thing that we wanted to get a better understanding from them is what information do they hear from investors that they want regarding climate change. In addition to the survey, we held focused in-person consultation sessions. We met with a very wide group of stakeholders, including issuers, investors, experts, and advisory groups, and I think collectively the CSA had over 50 consultations across the country. So with that context, I wanted to finish up with where we might go from here. There are many possible outcomes that could come from our review, including maintaining the status quo, publishing refreshed guidance, having an increased focus on climate change matters in our disclosure compliance reviews, and the implementation of new disclosure requirements. I should note that no decisions have been made yet. But that being said, there are a number of issues that we are considering in assessing whether further regulatory action is warranted. First, what is meant by climate risk? And this is key. In my view, it is important to look at the issue from a business or financial perspective. Second, what are current disclosure practices in Canada, and are they adequate? Some stakeholders have noted that there are varied practices across issuers and across industries. That, in turn, they have noted has made it challenging for consistency and comparison among issuers. Another consideration relates to materiality assessments. As mentioned, we are seeking to better understand how these assessments are being made in the climate change context. Some stakeholders have indicated that where there is no climate risk disclosure, it may be helpful to understand whether the issuer has considered climate risk and determined that it was not material. On the other hand, we do not typically require an issuer to state that an issue is not material. Another question we're asking is whether information about climate risk do investors and other users of disclosure reasonably need. And it is important to remember that investors and users are not necessarily a homogeneous group, and their needs may vary. We have retail investors versus institutional investors, investors who have more familiarity with the issue and others who have less. We have long-term investors versus short-term investors. What are they looking for? Are they looking for disclosure regarding governance and oversight of climate risk, disclosure of material climate risks, Scope 1, Scope 2, or Scope 3 emissions data, or scenario analysis? It is important to understand what information is actually needed in order to make informed decisions, and it's also important to consider the cost benefits of providing such disclosure. Finally, some stakeholders have noted that there is a multitude of different reporting requirements and frameworks, and it would be helpful to have one common standard. That may help to facilitate consistency and comparability among disclosures and could potentially relieve some of the reporting burden on issuers who may face many requests for surveys or other information. That being said, it is also important to remember that in Canada, we do have a unique capital market with having a large number of venture issuers. So as a result, we do need to take a step back and think about what is appropriate for the Canadian capital market. So these are just a few of the issues that we are considering. It's by no means an exhaustive list. The impacts of climate change can be far-reaching and occur over the short, medium, and long term, but they may impact each issuer differently and to a different extent. So the final thought I'll leave you with is that boards need to consider and understand these risks and to disclose these risks where they are material and needed for investors to make informed investment decisions.
Thank you. So we'll hold our questions until the end, and I'll pass it over to Judy.
Okay, thank you. I don't have a PowerPoint, so you have to listen to me, which is particularly bad because my cold makes me sound really ugly, so I'm sorry for that. So why is RBC Global Asset Management here, and what is our interest? So we are an active investment manager, managing about $400 billion in assets. About half our assets are institutional clients and half are retail clients. And we are about 4 years into a program to comprehensively integrate environmental social governance, or ESG factors, into our investment process across all of our investment teams and all of our asset classes. To date, we haven't approached climate change as a theme, but I can tell you certainly for climate-impacted sectors, this is something our PMs are developing incredible expertise at, and it's something we raise in our engagements with the companies in which we're invested as well. So our team supports our investment managers integrating ESG, and we also do all of the voting for all of our funds centrally, and we direct all of our ESG-focused engagements. I think we have to acknowledge, and this echoes some of Kristen's comments, that really the idea of a financial institution like an asset manager or an asset owner approaching climate change as a broad thematic risk really is quite new. I mean, it's to be applauded, but I think we need to have kind of a level set in terms of where we're actually at right now. And that's certainly what we're seeing in corporate reporting. So just a couple of days ago, KPMG issued an update of their global survey of sustainability-related reporting. So they looked at 49 countries, the 100 largest companies in each country, and then the 250 largest global companies. And they found that 78% of them are integrating financial and non-financial information into their annual reports. So that is certainly encouraging because that is an increase in sustainability-related reporting. But 72% of that larger group of 4,900 companies are not acknowledging climate change as a financial risk at all in their annual reports. And 52% of the globe's largest 250 companies are also silent on the issue. Interestingly, 5 countries were identified where a majority of the companies in those countries are acknowledging climate change risk, and Canada was one of them. And the reason given is probably obvious because Canada has a high proportion of climate-impacted sectors, oil and gas, forestry and paper, metals and mining. But what's quite interesting is the reason given for the other 4 countries was the existence of mandatory ESG-related reporting. So I think that's something that the regulators should really think about. And it dovetails with a study done by the PRI, the UN PRI, and MSCI last year, which looked at 300-odd ESG-related laws and regulations across the globe, and they concluded that in countries where ESG reporting requirements are widespread and mandatory, those companies within those countries have about a 33% higher MSCI ESG score. Now, we don't put a lot of weight on scoring, but it's certainly interesting as an indicator and suggests that there's a role for some mandatory reporting to play. So against this backdrop of what I would call quite limited and nascent corporate reporting, what do investors want? And I think the simple answer is investors definitely want more than they're getting now, and they're not interested in boilerplate risk disclosure, which is some of what you're currently seeing. CPA Canada did a study of climate-related disclosures of 75 Canadian companies, and while there was a fair bit of disclosure, perhaps a little more than the global stats would suggest, there was a lot of boilerplate that really isn't investor useful information from a PM perspective. So I certainly agree with what Joanne said and what is in the task force recommendation and in the SASB report, that any disclosure should be clear, it should be consistent, and it should be comparable across industries and across time frames. And I really like the TCF D framework around governance, strategy, risk management, and metrics and targets. I think it's really logical. And I think an important point that I don't think we've talked a lot about today is that the governance disclosure and the risk management disclosure should not be subject to a materiality threshold, because that's really focused on what is the process the company is following to identify, manage, mitigate climate-related risk. So you don't need to put that through a materiality filter in order to include it in your disclosure. But I think we can't diminish the difficulty of determining materiality in this context. I think it's something companies really struggle with, and I can tell you it's something that portfolio managers struggle with as well, especially around the time frame. So the time frame of climate-related impacts, the time frame of potential regulatory change, the time frame around disruptive innovation and technology is really difficult. Which is not to say it shouldn't be done. I think companies have to struggle with, work it out. But I think it's important to acknowledge that it really is quite difficult. But here is where, and it's something Sarah touched on before, I think director education is really key, because I think it's more difficult when you're thinking about climate change from 40,000 feet and trying to think about how does climate change impact my business. But I think And I agree that the CPA Canada questions directors should ask is a very useful high-level guide, but I think every director should be reading the SASB technical bulletin on climate change and the more granular recommendations in the TCFD report for certain sectors, and actually reading through it to get a really good comprehensive understanding about how these issues may impact their business. And I think that once they do that, it is really hard to imagine a director concluding that there are no material impacts to their business. So I'm really encouraging boards and directors themselves to actually read through. They're not difficult reads, and they don't necessarily lead to voluminous disclosure. SASB's recommendation for industries has just 4 metrics and 2 topics per industry on material climate change related risks. So this is something that directors really can manage. I think that, however, directors are definitely reluctant and afraid to put these disclosures in their core financial filings, which is the recommendation of the TCFD. And as a lawyer by background, I understand that reluctance a little bit. And certainly what I'm seeing in Canada is that reluctance is causing them to do nothing because they're worried about liability for the disclosure. So certainly as investors, I think we're open to seeing that disclosure, at least initially, outside of the core financial filings, with the caveat being that the disclosure around governance and risk management, because it's not subject to that materiality filter, absolutely should be in the core financial documents. But I would certainly be open to seeing it, at least initially, outside of the core securities filings, subject to the caveat that it should still be made in accordance with the the TCFD framework or the SASB framework, because what we don't want to see is something that someone talked about before, I think it was Andrew, kind of the fluffy, promotional CSR reports that we see now that are really not decision useful from an investment perspective. So I think sometimes it's better to get it done than to get it perfect. I agree that it's better to have it in the core financial filings, but I think we would be open to seeing it elsewhere, provided that it follows one of those two frameworks, and also provided that, as Andrew said, it's reviewed by the board and subject to the same level of ownership and accountability that the core securities filings would have. And I think that at least that way, investors can begin to test companies' hypothesis that it's not material and it doesn't belong in the core financial filings. We can start that conversation with companies and begin to encourage them to elaborate on the disclosure. And quite frankly, it will allow regulators to make an assessment about whether they think it's material as well. So I think it's an important first step, and it's better than doing nothing. And on the regulatory front, I'm certainly in favor of the regulators maybe just reminding companies, because Joanne pointed out a lot of this is really already there, but a reminder from the regulators that companies should be disclosing their material ESG-related risks, I think would really be an important positive development. You know, we saw it in Ontario with the regulations for Ontario-based pension plans when they were required to disclose whether they integrate ESG, and if so, how, which is a very benign regulation, really caused an enormous amount of interest from Ontario-based pension plans and a lot of opportunities for education, because believe it or not, a lot of those trustees were saying, what is ESG? So a reminder by regulators that either that those requirements are there, potentially buttressing them, but I would be a little bit reluctant to see the regulators adopt the TCFD recommendations wholesale. I think it would probably be better for them to point to it as a useful framework, point to the SASB framework as a useful framework, and allow companies to start to develop their own approach in accordance with those frameworks. And part of the reason for that is that some of what are in those recommendations is a bit controversial, and I use carbon footprinting as the example. The recommendation is that every asset manager and every asset owner should produce a carbon footprint. I think that is a problematic recommendation. It's certainly the case that a lot of our clients are starting to get more interested in a carbon footprint for their portfolios. We have done a lot of work on it. We can certainly produce them for our clients. But I see that there is very limited understanding to date about what a carbon footprint actually shows and what it doesn't show. And I worry that there'll just be this sense that, that we can just produce a carbon footprint and then we're done on the climate change file. And so I wouldn't want to see too much emphasis put on that. And we've done a lot of work on carbon footprinting, and there's a lot of problems with the data, not the least of which is that 50% of it is estimated. And depending on the different estimation methodology you use, you get a radically different number. And it's not, and I was actually quite gratified to hear Ben's comments about it not being a really meaningful risk measure. And I think, again, carbon footprinting can play a role, but I really think it's important for people to understand what it shows you and what it doesn't show you. And so my certainly my preference would be for regulators to remind companies that they should be disclosing material ESG-related risks, including climate change, maybe some additional guidance around climate change, and then pointing to those two frameworks as really useful and interesting frameworks that will help investors make better investment decisions. And I'll leave it there.
All right, great, thank you. Over to Sarah.
Okay, I'm going to talk about disclosure with my lawyer hat on, not my asset owner hat on. And I'm going to talk about the TCFD as a mandatory disclosure framework.
I don't think this disclosure framework is voluntary. I actually do think it's mandatory. I'm going to talk to you about why, and I'm going to talk to you about all the reasons that I see as a lawyer given by our clients as to why it's a legal risk for them to comply with the TCF D, and to discuss why that is misplaced. So first of all, why is the TCF D a mandatory disclosure framework? Why are these standards so significant? And the answer is, firstly, well, who's promulgated it? The G20. Canada is a member of the G20. Australia is a member of the G20. UK is a member of the G20. Who sits on the task force? Yes, Michael Bloomberg, 9th richest guy in the world. But not only that, on the task force are the who's who of participants in financial and commercial markets around the world. From the world's largest bank, the Industrial Commercial Bank of China, HSBC, all 4 of the major accounting firms, the 2 major credit ratings agencies, Standard & Poor's and Moody's, BHP, Mercer, AXA. These are influential financial market participants who are themselves going to be applying this framework. And so we see it moving from gold standard best practice to the way things are done very, very quickly. So I think for my clients, I certainly advise them that it's a voluntary standard, but it's mandatory to have regard to it. And it is very much, to my mind, the greatest legal risk for you if you remain silent on this risk. So that, in fact, was the theme of a report, the lead author of which, this is the second time I've given Alexia a shout out from Client Earth, that the CCLI recently published. Concerns misplaced. Will compliance with the TCFD recommendations really expose companies and directors to risk? The conclusion was 2 words: hell no. And while I'm up here, just a little bit of indulgence. Our report is now ranking #1 on a natural search of Google, even above the task force itself. So I just wanted to put that out there of how much of an influence the CCLI is having on this issue. So what I'm going to do is talk about 6 common fallacies that I find and 6 excuses that are used by directors and their legal advisors about how they can't possibly comply with the TCFD. So first of all, climate risk is not material to us. Oh my Lord. So Joanne's already talked about materiality, and that same kind of qualitative approach to materiality is reflected all around the world, in disclosure frameworks all around the world. The obligation in reporting is to present a true and fair view of business performance and prospects. And prospects. And information is material if a reasonable investor would find it decision useful. So, would a reasonable investor find information about how climate change may impact on business prospects decision useful? This is a chart that demonstrates what the World Economic Forum thinks about climate risk as a material economic issue. Every year, the World Economic Forum, not known for its environmental hippie conscience, puts out a list of what it perceives to be the top 10 risks to the global economy. And for the first time last year, #1 was a failure of climate change mitigation and adaptation. And if you go down that list on the right-hand side, you'll see that just about every one of those has a direct relationship with climate change. Water crises, large-scale involuntary migration. If Europe's having trouble with a couple of million refugees out of Iraq and Afghanistan and Syria at the moment, what's going to happen if we hit 4 degrees by the end of the century and you have 1.5 billion people in the Indian subcontinent without a source of fresh water? Energy price shock, biodiversity loss, etc., all directly related to climate change. People often ask me about the impact of the scary American on this. This is my scary American. His name is Larry Fink. Kind of looks a bit like Uncle Larry Fink, doesn't he? Who's Larry Fink? Who knows who Larry Fink is? Larry Fink is the CEO of Blackrock. Who is Blackrock? Blackrock is the largest investor on the planet. They have $5.4 trillion worth of assets under management. On average, that equates to 7.8% of every listed company in the world. Larry is huge. When Larry says jump, companies listen. Larry has said for the last few years, climate change is a material financial risk to Blackrock. He writes a letter to the chairs of the companies they invest in every year. And he hasn't been satisfied with the response that he's been getting. So this year he went a bit further and said, we are actually going to talk to the non-executive directors of the boards of companies in which we invest. And we expect demonstrable fluency. Isn't that a great phrase? Demonstrable fluency in relation to how climate change impacts on the performance and prospects of the business from a financial perspective. And we are going to start voting against those directors if they cannot show demonstrable fluency. The other 5 largest investors in the world, from State Street to Vanguard to the Norwegian Sovereign Wealth Fund, have all come out and said similar things in the last 6 months. This is a material financial risk issue for us, as has Moody's and Standard & Poor's, the credit ratings agencies. You cannot say that this is not a material financial risk. Full stop. If it doesn't impact on your performance, it impacts on your prospects. So, busted. The second fallacy we have is, forward-looking statements. We are going to expose ourselves to huge liability if we make predictions about how this might play out and we are wrong. Therefore, we are better saying nothing. That misapprehends both the nature of the recommendations around stress testing and scenario planning under the TCF D, and actually also what the law on forward-looking statements says. The law on forward-looking statements requires you to have objectively verifiable, reasonable grounds to support your prediction as at the time the prediction is made. So what you are obliged to do is look at the best information that you have and deal with it at the time. And of course, you can put appropriate caveats around the scope of uncertainty. But you need to do it. And what happens if you say nothing? What are you representing if you say nothing? That it's not a material issue, or that business as usual is the most likely future that you're planning around. Busted. Next fallacy. It won't be misleading if we talk about opinion or belief. We believe that the price of oil is going to go back up to $100 a barrel by the end of the decade. Often this is relied upon as, a bit like in marketing, if you put something in quotes, people think that you won't be held to it as a statement of fact. If you frame something as a statement of opinion or belief, you're representing A, that you genuinely hold the opinion, and B, you have a robust process of analysis that has sat underneath your forming of that opinion. So you still can't get out of doing your 5 E's as a director that we talked about this morning and actually go through the robust process and just frame a disclosure that is convenient to you as a statement of opinion and think that that will get you out of liability. The boilerplate. One of the alarm bells for me with corporate disclosures is if their disclosures around climate change don't change year on year, because it means it's the boilerplate. There's this great quote in a US case called In Re Harmon that is quite authoritative because the Supreme Court looked at whether or not they were going to hear an appeal from it, and they said there is nothing to see here. So in this case, the court used this great analogy in relation to boilerplate disclosure, and they said, it's like if you were hiking and your companion said to you, your hiking companion said to you, watch out, there's a ditch ahead. when it's the Grand Canyon that's 6 feet away. And that is exactly what boilerplate disclosure. It's meaningless just to disclose that climate change is a risk. It's not decision useful to an investor. Cherry picking of favourable scenarios, and this is where there have actually been quite a few live cases. The International Energy Agency puts out different projections in relation to what demand for fossil fuels would look like out to 2040, depending on which trajectory the global economy takes on climate change. So if we continue to follow a high emissions business as usual trajectory, they say, well, this is what demand for coal would look like, and oil would look like, and gas. On the other hand, if there's a new policy scenario and the governments do everything that they've currently said they're going to do in relation to climate change, well, that will curtail demand for coal, oil, gas a little bit. And then if we follow the 2-degree pathway, well, that's not going to be pleasant for coal, oil and gas. And there have been situations where fossil fuel companies have quoted the International Energy Agency statistics in relation to projected demand for coal and oil, but they've cherry-picked only the business as usual scenario. And the New York Attorney General actually prosecuted Peabody Coal in relation to their mandatory filings with the Securities and Exchange Commission, where they had only cherry-picked that one scenario as being misleading to investors about the prospective risks to their business. And the last fallacy I see is that, oh my God, this is such a big issue. Who knows? Who knows? What are directors? They are professional managers of risk and strategy. What is risk? It's the impact of uncertainty on objectives. It is their job to look at these issues and futurecast. It's no different to what's going to happen with demographics, what's going to happen in North Korea, what's going to happen to the Chinese economy. It's hard, it's uncertain. It inherently requires you to pick a point that's ambiguous and justify it. But the only certainty is that there is going to be change. And so you need to stress test and scenario plan around, okay, well, what is the plausible range of climate futures that we have here? You know, on one hand, we've got the 1.5 degree scenario. Wouldn't that be great? Which minimises physical risk, but geez, it maximises economic transition risk. So what would that mean for our business? At the other end of the spectrum, we've got business as usual, which means very little economic transition risk, but a whole stack of physical risk. What does that mean for our business? It's hard to do. It actually requires application of thought and effort. God forbid. So, that's my view on the TCF D. You've got to have regard to it. What is it? It's a framework that says, okay, this is a material risk. What information do you need to disclose to present a true and fair view of that risk? And as a director, you reverse engineer from that and say, okay, well, what do I need to think about then so I can disclose it? It's a really useful framework. And if any of your clients are saying to you, oh, this is some fringe, hard, difficult thing, you need to warn them that they will be in the gun.
All right, thank you. So we've got 10 minutes before lunch. I have questions, but I am sure you do as well. So why don't we go to the floor? Not looking at anyone in particular except Andrew.
Thank you for this panel. I am absolutely enjoying it. So I have a question, and it's for the panel. If as Joanne says, we have a range of investor needs for information on climate risk, and if we have companies already filling out surveys, and as a result of that, data is generating sort of ratings, can't we just outsource what we need from an investor perspective at the institutional level, all of this information to the rating agencies? Why would we need to put it into the securities disclosure if we've got what we need through the completion of these CDP reports and the summations of the results coming out of those?
Want me to start? So by rating agencies, you mean kind of ESG-related rating agencies, not credit rating agencies? Yeah, so I would say no, we cannot. First of all, a lot of those ratings and that information is actually really poor quality, updated once a year, which in and of itself makes it not investor worthy. When we do purchase ESG-related research. When we did, we had our quant team do an analysis of how often they correlated, because we thought, if they're both saying the same things, we don't need all of them. And they only correlated 57% of the time. The other times, they were radically different. You could have one calling one a sector outperform and the other one identifying it as a dog. So I don't think on ESG-related issues broadly, and particularly with respect to climate, that kind of quantitative once-a-year analysis is investor useful. I think we need to know how the directors are thinking about this as a material business risk, how they see it might impact their business going forward. And I say this for all ESG-related issues, and certainly with respect to climate. And it should be changing, often. And you need that board qualitative assessment about how it's impacting the business and risk going forward. And I just think you're never going to capture that in some kind of quantitative survey and research put out by kind of climate or ESG-related rating agencies. And interestingly, although GHG emissions obviously play an important role, I thought it was really interesting that SASB said that emissions are actually only material for 23 of 79 industries, whereas climate change is material for 72 of 79. So there are issues other than just emissions that are relevant. And I raise that because emissions are arguably best captured through that kind of quantitative data gathering, but they don't tell the whole story. It's a long answer. But.
And I would actually add to that. So first off, I think material risks are required to be disclosed under securities regulatory filings, because that's set out in securities legislation. But I think the other point I would highlight is that there are 3 levels of oversight of information in securities regulatory filings, and I think that provides a lot of rigor around the quality of the disclosure. So first off, the audit committee needs to review financial statements and other financial information. Second off, the board needs to approve the documents such as financial statements and MD&A. And also the CEO and CFO have to certify that that information is correct in all material respects. So I think those 3 levels of oversight of disclosure in securities regulatory filings does provide rigor around the accumulation of this information and the reporting of this information.
Hi, Keith Stewart with Greenpeace. Thanks so much. It was a really fascinating panel. One of the questions I had was, there's a major step change from sort of current levels of disclosure that's in the TCFD, as I see it, which is the 2-degree scenario modeling. And that would be something which, I would say that there's some companies who probably really don't want to do it because it's not going to look good for them. So how do you see that? In sort of for the OSC, you had sort of your 4 levels of, here's possible outcomes. And I really, not all of them would force companies to do that. And I'm just wondering some reflections on that.
Sure. So I'll reiterate, no decisions have been made yet, and we've obviously very carefully reviewed the TCFD recommendations. And we have consulted with numerous stakeholders, including issuers and investors, regarding the various aspects set out in the TCFD recommendations. And regarding scenario analysis, I think it'd be fair to say that there are mixed views on the utility of scenario analysis, just given that there are numerous assumptions that would be made when conducting those scenarios. and query whether or not that would provide meaningful disclosure. That being said, we also heard that it could provide meaningful disclosure. So I think there's very mixed views as to the utility of that. And so that is feedback that we are currently considering.
And I should mention too, Jane mentioned it, the UNEP FI has partnered with, I think it's 13 global banks, and our parent, RBC, is one of them. And they've gotten together to kind of figure out exactly how should scenario analysis be done and maybe have some common assumptions. And I think they're going to look at, I could be wrong, but I think it's a business as usual 2 degree and 1.5 degree, I believe. But as Joanne said, I think it's, we've talked to our PMs a lot about this, and it's going to be really important for those assumptions and inputs to be disclosed in a meaningful way in order to really see the value of this scenario analysis. And, you know, anecdotally, they said in many ways they would rather have the underlying inputs so they themselves could run a scenario with their own assumptions. So I think that this is going to evolve and change, but I do think meaningful disclosure of assumptions and kind of the guts that's going into the scenario analysis will be important. But I think it's really positive sign that, you know, you've got 13 of the world's largest financial institutions getting together to figure out how it's going to work. And ideally, I guess they'll come up with some commonality, because comparability is going to be really important for it to be meaningful as well.
I think the choice with the scenario planning and stress testing now is, do you want to be negligent, or do you want to be guilty of securities fraud? Take your pick. You have to do it. You have to do it. And it has to be defensible. And the whole idea of doing this, it's just risk management 101. You want to know what the range of plausible scenarios you're dealing with. I mean, Paris has been called the mother of all market signals. We haven't in history had another situation where you've got 196 countries saying this is the goal that our policy is going to be directed towards. We're not there yet, but that's our target. I think the accounting firms have a huge role here. And to my mind, it's going to be interesting to see that where they start putting their money where their mouths are when they're doing the audits, and whether they start refusing to give unqualified audit opinions where they know that the companies have not done stress testing and scenario planning, or that the assumptions are, that underlie both the financial statements and the MDAs, which is the director's report on business prospects and risks, are overly optimistic or singular. Are they going to start calling that out? And if they don't start calling that out, are they going to start being sued by Greenpeace for themselves being negligent and not doing their job properly?
All right, we have one last question.
Hi, this is not so much a question as perhaps a comment in response to Sarah's point. I'm a CPA, and we're not seeing the accounting firms doing much in this area at all. So if you're asking this question, it is going to take someone going after one of these audit firms to get any reaction in this area. I agree wholeheartedly. Accounting firms are integral to this whole process, and they have been remarkably and are remarkably slow.
We had a roundtable in Australia recently with all our securities regulators, and we invited all of the big four accounting firms. Their heads of sustainability consulting get this. And they were told to BYO crusty old audit partner to this roundtable, because like any big organisation, they're siloed. The audit partners don't get this. But the knowledge will be imputed to them as a firm. They've been part of the TCF D process. They've signed off on the TCF D recommendations. So if I was insuring one of the large accounting firms now, I would be really worried from a D&O perspective that they're not doing what they've said they're going to do because of that lack of knowledge. In any of this, lack of knowledge is not the test. It's what should you have known, or what did your firm say you did know? So I think there is also a role for the accounting organisations to really start pushing this information through hard as well, because otherwise the members are the ones who are going to be targeted.
All right, we're going to leave it there. Lots of food for thought, and the conversation can continue over lunch.